At any time you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
Welcome back, because today's breakdown is one you don't want to miss. We're zeroing in on a self-proclaimed sovereign citizen I've been tracking for a long time out in Thurston County, and after months of delays and disruption, his case is finally reaching a critical point. With a jury trial now right around the corner, this is the moment to connect every hearing, every argument, and every tense courtroom moment into one clear, no-nonsense timeline. This isn't just a recap, it's the full story of how repeated clashes with the system led us straight to this high-stakes trial. By the time he walks into court again, you'll already understand exactly what happened, why it matters, and why what comes next could change everything. Let's get into it.
Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
so Mr.
Had this matter before,
yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
Oh, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
That has to rank as one of the weakest justifications imaginable for choosing self-representation when your freedom is literally on the line. Picture this. You're in Los Angeles and you're told you have 24 hours to reach New York or everything falls apart. Are you seriously rejecting a trained professional whose entire career is built on getting people safely from point A to point B, just so you can take the controls yourself with no experience? There are plenty of things in life you should handle on your own, like tying your shoes, getting dressed, or remembering basic safety gear. But there are also moments when common sense says you hand the reins to someone who knows exactly what they're doing. Operating an aircraft, performing delicate medical procedures, and navigating a courtroom where your future hangs in the balance all fall into that category. This isn't confidence or strategy, it's reckless overconfidence, and instead of gaining an advantage, he's steering straight toward a hard landing.
Okay. All right, well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as, what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
Let's be clear from the start. The moment you chose to operate a vehicle on public roads while violating the rules, you entered into the court's authority. No mystery, no hidden doctrine, just basic law. That isn't profound insight or secret sovereignty knowledge, it's everyday reality. And that entire routine about the court being in praise while you're supposedly enforcing some personal rule wasn't legal brilliance, it was noise dressed up as confidence. Here's the truth. The court is in praise because it's the court of original jurisdiction, the place where decisions are made before anything ever moves to a higher level. A fact plainly explained in standard legal references where the terms are used interchangeably. So when you announced that label like it was a revelation, you weren't uncovering a loophole, you were openly admitting the court's authority over you. Well done, you dismantled your own argument in real time. As for that so-called rule, it's nothing more than a procedural court order that activates under specific conditions, and since you are not a judge, you won't be enforcing it today, tomorrow, or any day at all. Watching this attempt is like seeing someone insist they can command a storm by sheer belief, bold, dramatic, and completely disconnected from reality.
It's also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
Well, Mr. Valentine, I'm going to hold you on $15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So $15,000 cash or bond has to be posted on each one of these separately, and then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law-abiding in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
Is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
Talking to my clerk, 1 second. And make it clear to him that he's proceeding pro se and that we need to do it.
I am not pro se. I'm sui juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The Supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
So now he's taken the argument even further, claiming he isn't actually himself but some constructed persona existing in the likeness of another individual, and this is where the logic completely collapses. If anything, he should hope the judge recognizes him as a person, because the alternative offers no protection at all. Rights don't apply to abstractions, and inanimate things don't receive due process or demand jury trials. When you argue yourself out of personhood, you're not making a clever legal move, you're sawing off the very branch holding you up. It's self-destruction disguised as deep thinking, and the only one convinced by it is the person making the claim.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are different things.
No, I'm not interested in semantics. So you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that. So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm of sound
I'm
mind.
not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel. We can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
You don't get to consent to a court order any more than you get to consent to staying in jail. Your approval isn't part of the process because that's simply not how the legal system works. Court orders aren't optional, and jail isn't a choose-your-own adventure. Now, let's move on to his next hearing. And trust me, things take an even stranger turn. This time, his entire family shows up in the courtroom and the dynamic shifts fast. What happens next tells you everything about how deeply this sovereign citizen fantasy has spread and how hard the judge has to work just to keep the room grounded in reality.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah,
I would
hold on,
like
hold on. I'll let you know when I need to hear from you.
Okay.
So, Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation.
Okay.
I have advised.
Okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
If this judge wanted to intimidate him, it wouldn't take a gavel or raised voice. Something as simple as basic logic would do the job. But intimidation isn't the objective here, not even remotely. What's actually happening is far more telling. The judge is trying to help because it's painfully clear this man has no idea how to help himself. Every move he makes only compounds the damage, pushing him further into a corner he created on his own. The court keeps offering clarity, structure, and a way forward, and he keeps swatting it away. It's like watching someone dig straight down while a ladder is being lowered right in front of them, then insisting the problem is everyone else.
Do you have any questions for me? Other than that? No, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
People
just
of special appearance.
You're really going all out with this so-called special appearance today, and the highlight is that dramatic we the people moment delivered like it's the opening line of the Constitution. Bold choice, especially since that phrase refers to a collective of actual persons, which makes it unintentionally funny after you've spent the entire hearing insisting you're not a person at all. You can't invoke the power of we the people while arguing yourself out of the very group it represents. That kind of contradiction doesn't strengthen your position, it collapses it. At some point, you have to pick a lane, because trying to occupy both just leaves you going nowhere fast.
no. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you is why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
And that brings this hearing to a close. Nothing complex, just another showcase of classic sovereign-style reasoning delivered with absolute confidence and no awareness of how disconnected it sounds. The only real surprise was him arriving with his entire family like this was a live demonstration of exactly how not to approach a serious legal situation. Instead of gaining clarity, the whole scene felt like a public lesson in confusion, where certainty replaced sense and spectacle took priority over strategy. If anyone showed up expecting answers, they almost certainly walked out with even more questions.
Hi, folks. I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to...
Well, I object to that. You're not allowing me.
We'll note your objection. Thank you.
In plain terms, the court wasn't persuaded, the outcome didn't change, and he was sent right back into custody, so let's move on. Next up is technically the hearing after the next one, since the session in between never surfaced online, and based on the docket, nothing of value was lost. It appears another judge spent the entire time methodically denying his motions, shutting down each attempt to flood the record with sovereign-style arguments that carry no legal weight. Same pattern, same result, towering confidence, no foundation in law, and a judge forced into cleanup mode just to keep the proceedings on track.
To get you unmuted.
Yes, ma'am.
All right. So, there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not? Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony, to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
That's textbook behavior. He rejects the government at every turn, insists it has no authority over him, and spends every hearing preaching that he's above the law. But the second he wants something, suddenly that same government, and all the taxpayers he claims don't own him, becomes more than willing to cover the costs of his personal investigation. It's remarkable how quickly the rules bend when the sovereign citizen fantasy runs headfirst into real-world consequences.
That's not part of the motions I have here that were filed.
There was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was...
Yeah, I objected to his denial of those motions as well, because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th, and that was October 21st. I have a request to release you and your request for, let me get back to your court to dismiss these charges, motion to release you. And that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On 18th, on this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So, just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading, one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
Stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. All right. Get it.
That's
Thanks.
the state's understanding as well, Your Honor.
All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward, and the docket and your pleadings. So, as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
By now, he's already been handed all of his discovery, which begs the question, what's left to complain about? He has the evidence, the paperwork, every document the state is obligated to provide. At this stage, it's not about missing information, it's about keeping the performance alive. When reality doesn't back him up, he simply invents a new grievance, creating conflict just to stay center stage in his own sovereign citizen drama.
Okay, so a thumb drive that he could view those, a request form for the dash cams, what does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial would be was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The state had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court found that when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something, or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective with the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense, and they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed sui juris, because I have my own best interest in mind, and it seems that the public defenders that were appointed to me were not assisting me effectively, and this was creating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of the discovery rules.
There was no violation unless, of course, you weren't paying attention. The prosecutor clearly stated that all discovery had been provided to your original attorney, the one you ditched when you decided to go full sovereign citizen crusader. Once it became clear that your former counsel failed to pass the materials along, the state did exactly what ethics demand. They ensured you received every document, even while you were in custody. The judge backed them up on it. This isn't some elaborate conspiracy, it's just a basic process that everyone else in the courtroom navigates without issue, except for you.
Well, I'm not finding there's a basis in your pleadings or what I've heard today to sanction anyone for a violation of discovery. So I'm not going to do that. And now you're also, I don't know if this was dealt with, but throughout your pleadings, you're concerned about this district court having jurisdiction over you. Is that still at issue, sir?
Yes, there was some service issues, as I mentioned before, which for some reason keeps getting ignored. The state served my address knowing well that I was in custody. They didn't serve me the court docket for the last hearing, and that lack of service creates a lack of jurisdiction for the court.
I disagree. Those are different issues. Go ahead, though. Maybe you've got something else there. What?
Oh, I was just going to say there's also been a number of courtroom violations taking place, which is why the last judge ended up recusing himself. But beyond counsel being ineffective in mounting any defense, they convinced me to give up constitutional rights instead of enforcing any constitutional rights. They lacked to challenge anything that the state was doing. They didn't challenge or attempt to suppress the evidence. They didn't even share the discovery information with me upon my request. And the court also was violating General Rule 43, my personal pronouns, continuing to try to say I'm pro se instead of sui juris, not acknowledging my name or acknowledging my status as an American national. I also submitted a letter from the Washington State Attorney General's office where they're acknowledging my status as an American national. They're acknowledging my fee schedule, where for some reason this court hasn't been acknowledging my pronouns at all.
All right, now we're on the final clip of the day, and wouldn't you know it, our favorite sovereign citizen virtuoso somehow managed to scrape together enough cash to bail himself out. Quite the feat, especially considering he spent half this saga claiming money doesn't apply to him. I guess that also means he suddenly has the budget to hire that private investigator he keeps bragging about. But something tells me this investigation will probably be more Google searches and wishful thinking than actual results.
Okay, so Mr. Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is to everybody, I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial.
Mhm.
So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance of counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case, of what I was trying to get straight with prosecution, and none of those questions were answered, as far as the legal terminology that we're using.
So what they're charging you with, or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly is being meant by the legal terms being used.
Of course you don't grasp the legal terminology. Why would you? Clearly, the rules of procedure are just as foreign to you, and that's because, unsurprisingly, you never went to law school. And that's precisely why the Constitution guarantees the right to legal counsel, to ensure people are represented by someone who actually understands the terms, knows how the system operates, and can navigate a courtroom without self-sabotage. By rejecting that help, all you're really doing is proving exactly why it was necessary in the first place.
I'm trying to figure that out.
For example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so, all right, transcript of past hearings, something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
Yeah, I wanted
time.
the communication between previous counsel and the prosecution, the case transcripts, and the bonds on record, and oaths of office.
Okay, of the oaths of office of the prosecutor, who?
You and the prosecutor, and for the attorneys that I previously had.
Well, for me, you could just go to the auditor, state auditor, or in the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office. I don't
Would
find that.
the Office of Assigned Counsel can't provide me with that?
You can certainly, yeah, ask them too. Ask them for their people what they have. I can't say.
Okay, yeah. I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to.
Because even though I'm
Taking this
representing
to
myself,
court.
the court is still obligated to provide legal assistance.
The court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial. That would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
When I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
yeah,
I just
well,
don't want anyone speaking for me.
so you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. A lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be represented or deceived into taking someone else's opinion of how to handle things.
Well, you don't get to kind of pick and choose how it's done. We've appointed counsel at one point, and you didn't want to do that. I could potentially, and I can't speak for the Office of Assigned Counsel. You know, they're the executive branch government. I don't run their office. I simply find if someone is indigent or qualifies for public defense and say, yes, they can have one, and then that agency takes over. But at this stage, so
When I was made pro se, that is what Judge Brant Buckley had discussed. He said that I wouldn't have counsel represent me,
yeah.
but that I had legal assistance.
And now he's suddenly asking for standby counsel, ironically, the exact same offer the judge just laid out in plain English. Meanwhile, did anyone notice the identity crisis unfolding live? He's calling himself pro se now, even though he swore he was sua juris back when he was locked up. I guess sua juris was the jailhouse version, and pro se is the new persona for life on the outside. At this pace, his legal identity is changing more often than his case is moving forward.
I
So
communicated with Office of Assigned Counsel. They assigned me someone,
they did?
to help
Okay.
me. So
I didn't know
as
that.
far as I knew, that's what was going on.
All right. Have you talked then? I'm kind of wondering why someone's on here. All right. So since that you need to, have you had contact with that person since
Yes,
that
it's someone with the
appointment?
last name Thomas. I don't have it written down, but yeah, I've called and sent him some emails. I got him from the supervisor.
Mr. O'Connor?
Yeah, Mr. O'Connor,
Okay.
yes. He told me
All right.
someone, I think Alex Thomas or something like that,
Okay.
was someone he referred me to, and I've contacted them, but I haven't got a response back from them.
And when was that?
This was just before I got out of jail, so
Just the end of last month,
yeah.
somewhere around there.
Yeah.
Okay, or beginning. All right, well, so we're like 10 days to trial. You haven't talked to the attorney that's public defense has provided for legal assistance. And so is that part of why you're
Yes,
not
ma'am.
ready to go? Okay,
Yes.
because that makes more sense to me. All right, well, let me turn to Mr. Abid, who's representing the state on that issue.
State would have no objection to a short set over, Your Honor.
All right, so now just so you understand, you're asking for a continuance. It's a fair request. I would find what we call good cause for that request. But that would put us into an excluded period under the time for trial rules. And we would set another confirmation date, and we would set it, actually we'd set a motion date, confirmation date. Let me look at these motions. Motion date, confirmation date, and a jury date. We'd send those to you in the mail. And if you'd like a text message reminder, we'd send you one of those too. and then going to go on the process. And then at that point, then you contact, I would think you would want to contact Mr. O'Connor's office and be sure that you can hook up with the person you need to and discuss all of this with them and then be back. But we're going to set that motion hearing so that we have everything done. Now you filed everything. You filed a lot of motions. You've got everything filed. State needs to respond, and then the court will hear from both sides and make a decision.
Okay.
All right.